Greetings everyone. I am Chani Bajaj and I welcome you all to yet another insightful episode of our legal awareness series, Just Justice. As it is rightly said that knowledge is the only jewel which does not decay. Yes, knowledge is something which always adds up. To upgrade our knowledge, we have come back today with another episode. In the previous episode, we have discussed various aspects of guardianship. What are the kinds of guardianships available under Hindu Minority and Guardianship Act 1956? Who is a natural guardian? What are the responsibilities of natural guardian towards a minor? And all such questions. Today, we'll continue with the same and learn more about its aspects. For that, we have with us our legal expert, Dr. Gaganpreet, present with us in the studio.
Thank you for inviting me, Chandni.
So, ma'am, as we were discussing in the last episode, I would really want to know more about the role of mother with regard to guardianship.
See, as I told you while discussing the concept of natural guardianship, the mother is a natural guardian of the illegitimate children, both the minor son as well as the unmarried illegitimate daughter. But as regards the legitimate children are concerned, the priority has been given to the father, and the mother can act as a natural guardian of the legitimate children only if he ceases to be a Hindu or he is unfit to act as a guardian of the legitimate minor children. But as regards, if we go by the provisions of section 6 of the Hindu Minority and Guardianship Act, what is provided is that in the first place, father is the guardian of legitimate children, and after him the mother. So, in the normal course and the interpretation which was earlier given was that father comes at the first place, and after means that after the death of the father, the mother will have the right of guardianship over the minor legitimate children. But now this position has been clearly stated by the Supreme Court in two very important judgments, that is the Vandana Shiva's case and the Geeta Hariharan versus Reserve Bank of India case. In that case, the father was alive, but the custody of the child was with the minor, child was with the mother. So, in that case, when the overall welfare of the child was taken care by the mother, and she wanted to purchase the bonds for in the name of the minor child, it was refused that she is not the legal guardian of the minor, so she cannot be granted this particular right, and she fought the case, and ultimately this position was clearly reinterpreted by the Supreme Court, stating that after does not mean that after the death of the father, where the father is not taking care of the child or is totally reluctant in the, or he has been absent and he is never ever taken the pains of knowing about the welfare of the child, and if the mother is there and she has been consistent, the custody has been with her, and she has been regularly taking care about the welfare of the child. So, in those situations, such a mother can be considered to be as the guardian, and it is not so that the only when the father is dead that she will be considered. And as regards illegitimate children are concerned, the position is very clear that the mother is the legal guardian of the minor children. As regards the natural guardians are concerned, the stepfather or the stepmother, they are not considered to be as the natural guardian. So, the adoptive parents, adoptive father or adoptive mother, they are on the same platform as that of natural father or mother. That means their position is same. If a child has been taken in adoption, then the adoptive father and the adoptive mother respectively, they will be considered to be as the natural guardian. So, that is the position with regard to the guardianship.
I hope this would help a lot of women in knowing about their rights. So this brings me to my next question about the natural guardians. What are their rights with respect to the property of a minor? Can they dispose it?
So, as regards the powers of the natural guardian with regard to the property of the minor is concerned, the Act is very clear in that, and it specifically provides that the natural guardian, be it father or mother or even the husband of the minor wife, their power with regard to the disposal of the property is limited. They cannot transfer the property, and when I say the transfer of the property of the minor, they cannot sell the property, they cannot make a gift of the property of the minor, they cannot give the property under any kind of exchange or charge, or even mortgage the property of the minor for their own benefit. Whenever they want to make any such kind of transfer, the prior permission of the court is mandatory. It's a very, very important aspect that guardian cannot deal with the property of minor as if it's his own property. Wherever such kind of transfer is to be made, with regard, when I am saying transfer with respect to the mortgage or charge or sale or exchange of the property of the minor, if that is to be done, prior permission of the court is a mandatory or a obligatory condition. Second is with respect to the lease. Can the property of the minor be given on lease? In that, if the lease is for a period of 5 years, then that can be done, because ultimately money is also needed for the purposes of taking care of the child, and the guardian may be in need of that money. So the property can be given on lease for a period of 5 years. But if it is beyond the period of 5 years, then again that prior permission is required. And in cases, this is also provided that the lease of the property of the minor should not exceed 1 year beyond the time period when the minor attains the age of majority. That means in no circumstances the property of the minor can be given on any kind of lease beyond that time period. That is specifically provided, and again here it is keeping in the interest of the minor child, because if the lease is given on a period of 5 years and let's say the child was 17 years, so 17 plus 5, the minor will be that minor 23. Will be of 22 years by the time the lease is completed. So in cases where the minor is to attain the age of majority, the lease of his property, her property cannot be given beyond a period of 1 year on the attainment of the age of majority. So that is the restriction that and this restriction is keeping in view again the welfare of the child, that the guardian should not deal with the property of minor in that manner which is detrimental to the interest of the minor. And if there is a dire need, there is a necessity which actually requires such a kind of transfer or sale of the property, so in that situation the prior permission of the court is a mandatory requirement, and that can be done only in that situation.
Okay, ma'am. As you just explained about the rule of that after attaining majority, the lease should not extend beyond 1 year. In case such a thing happen or such a scenario occurs, so it could be challenged?
Yes, that property, if it has been given beyond that time period, it is definitely, it can be challenged by that minor. And even in certain cases, let's say the guardian has disposed of the property of the minor, stating that it was there was a dire need, and once the minor attains the age of majority and he feels that my property has been disposed of just like that and there was no such necessity, so it is voidable at the instance of the minor. Okay. So on the attainment of the age of majority, he can always question, because again something was in the name of the minor that was dealt in a manner which was in the interest of guardian and not in the interest of the minor. So if that kind of situation arises, definitely the minor can challenge such a decision.
Okay. So I think a lot of people would also want to know, and as you had explained earlier, the various kinds of guardian. So what are the testamentary guardians?
See, testamentary guardians are also specifically provided under the Hindu Minority and Guardianship Act. Under the provisions, testamentary guardians, as the very name suggests, testamentary means where the natural guardian makes somebody as a guardian by way of a testament. Testament means by way of a will. Let's say father is the natural guardian of the minor, and during his lifetime he says that okay, after my death such and such person should act as the guardian of my child. In case I am no more, after my death the guardianship should go to such and such person. But as far as now the act is concerned, after the death of the father, irrespective of the fact that father has named somebody else as the guardian of the minor child, but if the mother is alive, as per the provisions of the act, mother is granted or mother is to act as the guardian of such a minor. So in that situation, whatever is written in the will not be applicable and the guardianship will come to the mother. Okay. And now if the mother dies, the sequence is father is already dead and now the mother of that minor child also dies, and she never appointed anybody as the guardian of her minor children. So whosoever was mentioned in the testament of the deceased father, now that person will come in picture and that person will get the guardianship of the minor children. So testamentary guardian is the guardian who is appointed by way of a will or by way of a testament, and that testamentary guardian, normal course, they will enjoy all such powers which are enjoyed by the natural guardian, all those powers with respect to, until and unless something specifically is mentioned with respect to, let's say, the property of the minor, but in normal course they enjoy the same kind of rights as well as the powers which the natural guardian. And the situation that now the father is also dead and the mother is also dead, and whosoever has been appointed by the will of either of the parent, that will act as the guardian of the minor. And there may be situation that nobody is appointed by the either of the parent. Let's say the mother also died without writing any testament, but if the testament of the father is there, then that person will be considered to be as a guardian for all purposes with regard to the minor children.
Yes, ma'am. And what if the mother also appoints a guardian?
So then in that situation, the guardian appointed by the mother will act as the testamentary guardian for the minor children.
What if there is a conflict that the father has also provided for a testament?
But now the situations might have changed and the position might have changed. The person who was appointed by the father is no more, or let's say the relationships have become strained with the death of the father. So it's not something that that whatever is written by, because that was written at a prior time and mother was there at mother was alive, so she is to act as the testamentary, she is to act as the natural guardian. But in case she also dies and she appoints somebody else prior to her death, then that person will get the guardianship of her minor children.
Okay, this was quite useful. And what are the powers of the testamentary guardians?
See, as I just told you that the powers of the testamentary guardian, they are similar to that of the natural guardian until and unless something specifically has been provided by way of the will, that there is restriction with respect to the dealing with the property of the minor. And many a times under the Hindu law, the minor children, they have certain interest in the undivided family property. So in that undivided interest is to be taken care by the so-called karta of the family or the senior most member of the family, and for that purpose whosoever is appointed as the guardian or something, that will not be considered for the purposes of dealing with the undivided interest of that minor child. So even in that regard, the testamentary guardian's powers are synonymously or you can say they are equivalent to that of the natural guardian, but something specific if it is provided with regard to the dealing with the property, or let's say certain limitations have been provided with regard to the powers of dealing in the let's say giving away the property by way of sale or something, although the act is very clear with regard to the powers of natural guardian. So the similar powers they flow because they have voluntarily chosen somebody that in case they are dead, after the death somebody is there to take care, and the similar powers they are transferred to that testamentary guardian.
Okay, ma'am. And as you mentioned earlier, that there are also guardians which have been appointed by courts. Who are those?
See, as regards the guardian appointed by the court, that is under the secular legislation. For even if it is for a Hindu, if a court has to appoint a guardian in a situation where both mother and father are dead and somebody is to be appointed as the guardian because the child is a minor and there is property in the name of that minor child. So in that situation, the procedural aspects or the process for the appointment of the guardian, that is in accordance with the Guardians and Wards Act, which is a secular legislation. Because the as I told you in the beginning also, the Hindu Minority and Guardianship Act, it is an addition and not an in derogation of the secular law for the purposes of appointment of the guardian by the court, because many a times when there is nobody to take care of the child, some good friend of that or the family friends, they might approach the court for the appointment of the guardian of such a minor child. So the court will take into consideration all the eligible persons who can be fit for this particular responsibility, and then the court will appoint that okay, for the taking care of the minor's body or taking care of the property. There can be different also, that for the property purposes they can appoint or they can limit the powers of certain persons with regard to the taking care of that property. But whenever court is the intervention of the court is sought for the appointment of the guardian, and when the court appoints a guardian for the care of a minor child, such guardian which is appointed by the court is termed as the court appointed guardian, and it is in accordance with the secular law of guardianship.
So this also brings me to another question. You mentioned about de facto guardianship. Please throw some light on that topic.
See, de facto guardian is a guardian who voluntarily takes the responsibility of the minor child. Let's comprehend of a situation where both the parents, they are dead and there are minor children. And what happens in normal times is that the immediate relations, that is the paternal grandparents or the maternal grandparents or the uncles and aunts, or in certain circumstances even the close family friends, they come up and they start taking care of the child, and they in a way volunteer for that particular responsibility. As far as de facto guardian is concerned, it is that person who volunteers to act as the guardian of the minor child in the absence of the natural guardians. That means the father, mother, or the husband, as the case may be. But now because their minor children are there and somebody comes up, some close relation comes up and say that okay, I'll take care of the child will remain with me, and they start taking care of the child, that guardian who volunteers in that sense is the de facto guardian. And now under the act, this particular type has been, you can say, it's not a legal guardian for any purposes, because de facto guardian is just where the fact states that this person is the guardian, but he does not have any kind of legal right over the minor child. Yes, here if that de facto guardian is so concerned about the welfare of that minor child, that de facto guardian can approach the court, and if the court deems fit that this is the right person, that this person can actually take care of that minor child, can take care of the property of that minor child, as the case may be, so the court will evaluate that person's representation, as well as if there is any such counter representation by any such other persons, that some other relative is also there who is interested in taking the guardianship. So in that situation, the court will come to an assessment that who is the best person for the ultimate welfare of that child, and accordingly the court will appoint a court appointed guardian. So here comes into picture a de facto guardian now being declared by court as the, and once that de facto guardian has been appointed by the court as the court appointed guardian, so in now that person gets that power or that responsibility or the legal right of acting as the guardian. But otherwise a de facto guardian does not have any kind of legal right over the minor child, and he cannot intervene in any of the property of the minor child, because he is just a good friend or a relative who comes up or who shows up after the death of the minor, or death, or if both the parents are unfit to act as the guardian of the minor child. So that is the situation with respect to the de facto guardian.
So basically, a de facto guardian has to get his rights enforced through court.
See, earlier de facto guardian was very much in practice, but they were the ones who were misusing that powers, that keeping into, because the father is not there, mother is not there, and they used to deal with the property, or they started acting in such a manner which was not in the ultimate interest of the minor child, and many a times they even misused the minor child. The minor children, they were made to do household work, and all kind of misuses were there. So now the court, once that de facto guardian has been specifically provided that they cannot exercise any such power, if they want to have some powers, that will come through the court, and the court can restrict those powers also, that what will be the powers with respect to the minor's body, and what will be the powers with respect to the property of the minor.
Court's satisfaction has to be there.
Yes, that has to be there, and again the paramount consideration is the welfare of the minor child.
Yes, ma'am. Also, ma'am, if we talk about the changing scenarios, we have seen these days there are a lot of single women who have their own children. So what is the law say regarding guardianship of unwed mothers?
See, as regards unwed mothers are concerned, I have told you the position with respect to the Hindu Minority and Guardianship Act, and it provides certain specific type of guardians, and the natural guardianship has been provided to the father and mother and then husband or testamentary guardian. It has been specifically told. But as regards unwed mothers, there have been a recent development in that regard, and for that purposes, it's not under the Hindu Minority and Guardianship Act, but under the secular legislation. It has now been very clearly stated by the Supreme Court in the case of ABC versus the state, NCT of Delhi, that even the unwed mothers can be considered to be the legal guardian of their minor children, because many a times it happens, and it was the case that that unwed mother never wanted to disclose the name of the father, which has actually abandoned the child, or which has never ever thought of marrying that female. So in that situation, the court has now been very clear, and the unwed mothers, they have now been recognized as the legal guardians. But just for the sake of clarity, it's not under the Hindu Minority and Guardianship Act, under the secular legislation that development has come.
Okay, so there has been specific amendment in the general legislation?
No, there is no, it is by way of the judgment that development has come up. There is no such specific amendment in the law, because as you know that law is not just confined to whatever is the word of legislation. Law, whatever the Supreme Court or the apex court declares, that also becomes the law of the land. So that is by way of the legislation that such development has come up.
Okay, ma'am. This was quite very useful information. I hope our viewers have also got to learn a lot of things regarding guardianship. Kinds of guardianship, who can be natural guardians, who are testamented guardians, who are de facto. Even we have touched sensitive topics like single mothers and single fathers about their guardianship status. So this was all we had for this episode, but we promise that we'll come again with yet another episode and we'll touch a new area, that is regarding the inheritance law under Hindu Act. We thank you, ma'am. We are very glad that you come here and given us your precious time, shared such useful information with us. Thank you so much, ma'am.
It's a pleasure.
And every one of you, stay tuned with us till we meet in our next episode.